Starting from reparations, I mean, even the term already reparations is a term that is not in and of itself clear. What does that mean, repairing the harm suffered by victims of armed conflict, of what I call of Rome Statute crimes in particular? I think if we even look into the different languages, how it is translated, it is often translated simply as compensation. But you will see and hear today that reparations is much more than money. And as such, the term reparations is a term that we are quite familiar with in public international law over the past decades. When we look at the relationship between states and law, so to say, internationally unlawful acts that are being committed between states lead to the right of reparation of one state against another. That is where we know the term very well as lawyers coming from basically international law background. And of course, when we look at armed conflict, these are international crimes, but for example, the crime of aggression and an act of aggression is very clearly also an internationally unlawful act, as much as other international crimes are. So we are also aware that, like, for example, recently between Uganda and the DRC, that it is possible that reparations need to be paid by one state to another for the commission of such crimes. And that's really the relationship of which we hear a lot at the moment when in relation to Ukraine. If basically Ukraine is calling also for making it very clear that whatever is happening in terms of possible unlawful international acts, that this will lead to reparations for which also Ukraine will be the recipient. So there is this call that we hear a lot in the talking, but not only, and I will come to that. Then what we know reparations from is human rights violations. You know, the European Court of Human Rights, the Inter-American Court of Human Rights, they also award reparations to those individuals who come before them. And there we deal actually with, again, a relationship between an individual and the state. So it's the individual that gets a right against their state, normally their nation state, for the payment of reparations. That's what human rights courts award as well. And then beyond that, we have also within states such laws that allow for reparations to victims of certain categories. And that, for example, in Germany, they have a law, and I'm German, so I can add that, where victims of atrocity crimes can receive reparations from the state, in particular if basically it's not possible to get reparations from a person that is held responsible for it. But that goes a little bit in that same direction. There is a reparation between an individual, a relationship between an individual and the state leading to reparations. In relation to international crimes and Rome Statute crimes or serious human rights violations, this has been codified in the 2005 General Principles by the UN. And that's really one of the basic documents that show what reparations are and that each state is responsible to provide reparations to their own citizens if these violations occur. This document also defines the broad range of different measures of reparations. So there are compensation, so that's all about money. There's restitution, that means you create the situation as it was before. Compensation says you cannot create the situation anymore that existed before, so you get money instead. But there is also physical rehabilitation, psychological rehabilitation, material support, so to allow people, you know, in the situation in which they are now to move forward. There is the big understanding of the idea of satisfaction. So getting a judgment, getting the possibility to know where your loved ones were buried. All of that goes to basically the idea of receiving reparation in satisfaction, which is a form of reparation. And then towards the state, there is also the guarantee of non-repetition. So these crimes happened and the state has the obligation to act that this is not repeated. There's more to it. I mean, because reparation can be much more as well. There are symbolic measures. There basically any other measure that victims, communities find repairs the harm that has been suffered, which can be diverse kinds of harm. And they are felt in diverse ways. So that is the idea of the 2005 general principles. So I think that is important as a basic understanding of reparations and this relationship between the individual and the state, between states, and then now third, between individuals. So a person that commits these crimes can be held responsible, criminally liable, but beyond that also liable in towards a specific person. Criminal liability is about the state, you know, about the state or the international community determining this person has committed a crime. But the liability in terms of reparations is towards the victims of the crimes that that person has committed. In our national jurisdictions, this is often either treated by an annex procedure to a criminal trial or by a civil party right in the French system that at the end of the criminal procedure also gives a right to reparations, or you go with the title, with the judgment to a civil court and you ask for reparations. So these are the different avenues that you are having. So I think that shows all the three relationships that are principally there. Now we turn into the system of the Rome Statute and into the very specific role of the Trust Fund for Victims, which is, in the way you will see, it's a bit of a hybrid between all of that. And it's important to grasp that in a sense. So the Trust Fund for Victims, I will first speak about the organization, about the mandate, the funding, and what we are actually doing. And with that, I will set the scene for my colleagues to dig into the details, basically. Has been created by the Assembly of States Parties to the Rome Statute. So at the moment, there were 123 states parties. At the time the Trust Fund was created, there were a bit more than 60. So that was in 2002, just when the Rome Statute entered into force. All the states parties met and they issued directly a resolution that created the Trust Fund for Victims on the basis of Article 79 of the Rome Statute. So the makers of the Rome Statute had already provided for the idea of a trust fund. Why is that? They thought they had also, as Marina just mentioned, included most importantly, the possibility to award reparations to the victims of the crimes for which a person is being convicted. So that is in a way an annex procedure. First there's a conviction. If there is a conviction, of course, then a sentence, and then a reparation procedure that leads to a reparation order against the convicted person for the benefit of the victims of the convicted persons. And given that these are all mass crimes, the makers of the Rome Statute said, okay, we need to find a mechanism where the means of the convicted person, the money of the convicted person, is distributed in a fair way to all the victims. So they said that needs to be a trust fund, and the money of the convicted person should go to this trust fund for victims to give it to the individual beneficiaries, or to give it to all of them in a just and proper manner through its programming, basically. So that was the original idea. Now, to date, we didn't have a single penny. So when they created that resolution in 2002, the makers had also thought of that might be an option. So we now actually need to allow the trust fund to collect funds also from states, from private actors and others. And with these voluntary contributions, then the trust fund will be able to provide also that money to the victims. We have now just issued, or are in the process of issuing, a new strategic plan where we make very, very clear that the trust fund and the court, the ICC together, we are the pillar of reparative justice. One cannot be without the other. There would be a judgment, a reparation order, but without the trust fund, there wouldn't be implementation because there wouldn't be any funds, basically. And so the trust fund's main task, therefore, is, on the one hand, to provide reparations to the victims of Rome Statute crimes. And the trust fund is doing that on the basis of court-ordered reparations, but beyond that, also through country programs in all countries where the ICC is active. The trust fund can also have programs more generally for the benefit of victims. And secondly, the trust fund is actually raising funds so that we are able to provide and run these programs, given that the convicted persons very rarely have sufficient funds to run, to allow for reparations to the victims. And thirdly, we are also having quite an expertise, in particular on providing transformative reparations to victims. So with that expertise, we want to also be enabled, or we want to enable others, in particular states also, to move forward with reparation programs. And I have mentioned now the term transformative reparations. So what the Trust Fund has been doing since 2008, when we started the first programs, country programs in Uganda and the DRC, is always to focus on the current situation of the victims and to improve that situation. So it's about empowering the victim to transform actually into a survivor. So that is a very important effect that we wish to have on our beneficiaries in our programs by providing psychological and physical rehabilitation and supporting victims with, also beneficiaries, with socioeconomic measures. We really seek to empower them to move forward with their lives. And why is that so important? It is important because if we are able to address the suffering of the victims and to help them from the situation that they are in now, because they have suffered harm, often many years before, they are able to again contribute to their communities, raise their children in a good way. So we mitigate these otherwise really negative transgenerational effects on the families, on the next generations. And we contribute to peace and stability. So that's really essential in our understanding that in providing transformative reparations, we look into the future. We help development, but we in particular work on peace and stability over time. We haven't just focused on basically psychological, physical rehabilitation and material support. We also focus a lot on symbolic measures. It can be symbolic compensation. It can be also measures like currently in Côte d'Ivoire, where we make sure that the communities actually decide how to commemorate the crimes that happened in the past. So these acts of commemoration are also very important to healing and very important also to the next generations, because then they know the crimes have happened, victims and community feel recognized for the crimes they have suffered, and people can leave it behind and move forward. So again, a very important focus of our work. We have funding from, in particular, states parties to the Rome Statute. And over time, so to say from the first time we got funding to today, we have received about 40 million euro. But that's a yearly contribution from about 2.5 to 4 million. And in the last year, in 2023, we got 4.1 million euro. So with this money, we have been running projects in Uganda and the DRC. In Uganda, we have addressed about 68,000 direct beneficiaries since 2008, with in particular physical, psychological rehabilitation and material support. And in the DRC, similarly, about a bit more than 50,000 victims and beneficiaries. Beyond that, we have also conducted quite a number of training and peace building projects in these regions. But we started also in 2020, 2021, country programs in the Central African Republic, where Mr. Bemba, one of the convicted persons, had been one of the persons who have been running through a procedure before the ICC has been acquitted. A country program in Côte d'Ivoire, where again, a former president and a minister had been acquitted just recently by the court. And now also more recently, a country program in Mali, where we are addressing crimes that have been committed in other areas than Timbuktu, to which the court-ordered reparations relate. So we are at the moment running therefore 5 country programs and addressing, I think we don't have the recent numbers for 2022 yet, but for 2021, we have addressed about 18,000 beneficiaries, and many of them being survivors of sexual and gender-based violence. That means conflict-related sexual violence, of course. So all the beneficiaries have to be victims of Rome Statute crimes. At the core of what we are doing, we are of course providing reparations to victims of court-ordered cases, so to say, of persons convicted by the court. Now, to date, there have only been 5 persons who have been convicted by the ICC for Rome Statute crimes. We are not looking at crimes, offenses against the administration of justice. There are a few more, but for Rome Statute crimes. And we are providing programs for in 4 of these cases. 3 of them, Lubanga, Katanga, and Ntaganda, have occurred in the province of Ituri in the Democratic Republic of the Congo. And one of them occurred in Mali, in Timbuktu, for the destruction of the mausolea in Timbuktu. That was cultural heritage. You heard that Dr. Lostal is basically specializing in that, and she worked with us on that case. So I think that gives you a bit of an idea. So we are running at the moment 26 projects in 5 countries with at a value of about 5.5 million a year, or 6 million a year. And so we are really in need to increase our funding, because now we have used all the funds that we had received over time, and we really depend on receiving yearly contributions that amount to more than 6 million euro a year. So that is really our target at this very moment, to be able to continue all the programs, but also to start programs in new situation countries. To conclude, I think I would like to underline the importance of contacting any persons who have suffered from crimes that are Rome Statute crimes, meaning crimes against humanity, war crimes, crime of aggression, or genocide. Exactly. So these are the 4 crimes. Because when being in contact with victims and collecting their information, we are raising expectations of victims. So it is very important, and that is also something the Trust Fund works on together with the relevant sections in the ICC that are the first ones in contact with the victims, that we are really very clear on what will be the consequence of collecting such information. And of course, in the very first place, that's up to the state to determine, as we heard. I mean, the state is the primary responsible entity in charge of reparations. But it is also very important for the court, for the ICC, to know what will be the effect. And I think in that respect, it is generally, would like to underline that given the gravity of the crimes, and given crimes are committed in a situation of war and armed conflict, it is rarely possible to really fully restitute or fully compensate a person for what has happened. But it's very essential to allow persons to empower people to participate in a reparation program, to empower them to design reparations for their future, so that they are enabled to transform, as I said before, into a survivor, to leave this victim status behind. I think that is what needs to be achieved, in my opinion, with reparations in the very first place. We recognize people for having suffered harm, and we enable them to move on with their lives. That's really at the core of what can be done by an international community or by states, also in terms of financing.
First, maybe to describe the context to you, Germain Katanga was a leader in the Patriotic Resistance Front of Ituri in the east of the Democratic Republic of the Congo. We are talking about the same conflict as Thomas Lubanga, so that's 2002-2003, the civil war going on there. Germain Katanga was sentenced to 12 years of imprisonment for the crime against humanity of murder, and the war crimes of murder, attacking a civilian population, destruction of property, and pillage. for contributing to destroying the village of Bogoro in an attack. It was a big attack that left some 200 people dead, and that took place on the 24th of February 2003. The court set his liability at $1 million US, and this amount has been used and is still being used to repair the harm that his acts caused to a group of 297 victims. It is a very specific group of victims, and the court was able, as in the judges, they were able to identify this group at the stage of the reparations order. This is, of course, because we're talking about one specific event on one specific day in a very specific location. In that sense, it was, of course, much easier to determine the group of victims eligible for reparations than in all the other cases that my colleagues have mentioned and cases that are still ongoing at the reparations phase. The court ordered both individual reparations and collective reparations. The individual reparations consisted of a symbolic compensation, an amount of $250 US. And the collective reparations were fourfold. There was housing support, educational assistance, income generating activities, and psychological rehabilitation. I will first focus on individual reparations, which also will bring me immediately to my first keyword, which is agency. $250 US might seem like a very symbolic small amount, considering the harm that was caused to people, considering that a lot of people's houses were destroyed, their incomes were lost because their cattle, a lot of the people from that Hema community are herders, they had cattle that was stolen, was looted, all of their goods looted. So it might seem like a very small amount, but first of all, of course, for the context of the Democratic Republic of the Congo, we are talking about quite a significant amount. And why can individual reparations not be underestimated, in my opinion, is because it gives people a direct responsibility. I know there has been a reluctance for many years, and there still is surrounding the idea of giving people money straight away. There are a lot of humanitarian organizations active in the region, and they all have very finely elaborated programs that help people get an education, that help people get a job. So it's all about stability, of course. But what we have seen in the Katanga case is that a lot of people take up the responsibility and do something very constructive and something that brings stability to their lives with a symbolic amount that can even be so low as $250 US. What we saw is these individual reparations were handed out to people in a first phase. This created trust among the victim community because collective reparations can take a much longer time to be implemented. There are several constraints, which I will talk a bit later. But what we saw with individual reparations, especially with a group that is directly identified, that is quite easy then to implement. You organize missions and you go to the field, you meet up with these people, and it is very important that it is a direct contact, that you don't just organize bank transfers. It's very important that they see someone from the court in front of them to hand over reparations to them, especially with their legal representative there. It adds a certain value to these reparations that a bank transfer would not bring, is that you're then the face of the court. You're someone who listens to them, who acknowledges their suffering, and who gives them the awards that has been ordered by the judges, explaining the value of it, explaining the reasoning behind it. And we have seen from a lot of different stories from these victims that a lot of them have created their own small business, starting with that amount. And by the time that collective reparations came through, such as educational assistance, they were actually no longer in need really of that assistance, because they were fully able to provide for their own children with the business that they created out of that symbolic amount. So that is the first thing that I really want to point out, that when you give people a certain responsibility, a certain agency, they will make good use of that, and they will, within the context and taking account their own personal needs, do something that is valuable to them. I've heard also other stories of victims who used a part of that money to organize a big gathering with the family, to have just a nice big meal together, to talk about things that happened, to be together, to remember those that were lost, goods that were lost, which also has a particular value. I'm not saying that creating a business is more important than taking care of family. There are several approaches that you can take, and I think it is important that we give victims the agency to decide for themselves what they need and what they want to look further to the future. When we then look at the collective reparations, the remaining amount from the $1 million, so taking away the symbolic compensation, victims were divided into different categories depending on the harm they suffered. Each category had a certain amount of money that would be allocated to them. And it was then basically for victims, again, here comes the agency, to decide for what category of collective reparations they would use that amount. Some victims had their houses destroyed, so housing support was a very logical solution for that. A lot of them lost, of course, their income, so income generating activities, as in the Lubanga case, is a very logical solution for that. It is very important, and there we bring the second word, which is flexibility, that the reparations order is not too rigid. The more rigidity it contains, the more difficult it is to implement reparations according to the needs of victims. And these needs change as well over time. So income generating activities can mean very different things. Some victims wanted a motorcycle so they could drive that around and be a taxi, basically. That's the most important means of transportation in that region. Other victims wanted to buy cattle with them because they had been herders their whole life and they wanted to rebuild their livestock. Other victims just wanted various goods to have their little stall at the marketplace and to sell vegetables, oil, rice, all those different things. Then when we look at the educational assistance, it speaks for itself, of course. Through losing their income, they were not always able to cover for their children going to school. And education, as we all know, is key in overcoming poverty, in growing out of a conflict, in making sure that people have a future, that people have something to build on. So that is, of course, crucial within the implementation as well. And we saw that of the group of nearly 300 victims, there were almost 200 victims that made use of this educational assistance. Between those three categories, victims could divide their money, and that would, at a first intake, they would have a specific choice. At a second intake, the choice would be different. People would contact us over time through their legal representatives to let us know that the school was on their doorstep, basically, because they could not pay for education. So if they could please change their allocated amount from an income generating activity to schooling. So all in all, very clear, there was a very clear need for flexibility, and it was important that we could give that to them. And then as a fourth category within the collective reparations, you have psychological rehabilitation. This was, of course, not linked to a budget given to a victim. The idea is that everyone can benefit from psychological rehabilitation because everyone is affected in his or her own way. There are also victims that said that over time, they did not feel the need anymore for psychological rehabilitation, which is, of course, absolutely fine as well. think within this context, what is very important to point out is, because we're looking at a small group of victims, it was decided by the chamber that all of these reparations could not be implemented through an implementing partner, through a local partner in the field, but through the trust fund for victims itself. There were several reasons for that. Of course, you have a direct contact. It gives extra value if you're able to implement that yourself, if you have a direct, close contact to victims. The second reason is, of course, that using local partners, programming, that all costs money, and that portion of money could then now be used fully for the reparations owed to victims. And through that, with the close contact, brings me to my third point, is communication being key. My colleagues have mentioned it before. It is very important to stay in constant communication, and legal representatives of victims play a crucial role in that as well. Their role doesn't end when a reparations order is set out. That's just the start of a new phase for legal representatives. It's important that they make sure that their clients' needs and interests are still represented. And they have, more than anyone else, a very good contact, a basis of trust, and through legal representatives, there can be then another basis of trust built up with the trust fund for victims. So that is very important. I think what we see still now, especially in that region, is people are living in a very volatile environment. We see now, even with reparations that have been implemented, been given to people, that in the same region today, there are a lot of different militia groups active, which of course risk in part destroying in a way what has been built up again. And it is important that we stay mindful of that, and that we stay in contact with people, and that we try to make sure that whatever evolving needs they may have, we can still play into that.
I want to add something as well. I mean, given the work of Sunflower, and in particular, given, I think you're working with victims, not just in Ukraine, but also many of the people who have fled the country, and they're reporting the crimes and the harm they are suffering. There are two things. So first of all, I think it's very important not just to focus on any harm suffered to property, but also on the psychological harm suffered. And that's a problem for many. So I think it is probably advisable to think of also psychological support as soon as possible. And young people actually shouldn't really report that without psychological support in any case. And then second of all, I think taking what Adeline has said, the expectation part, but then not so much in relation to reparations, but really in relation more generally to why am I giving this information? It's very important to understand that not everyone will be convicted. That's very rare that this is happening. So not every perpetrator will be brought to justice. Not every victim is a witness. So I think that's also very important. And it's also very important to respect actually that there are victims who don't want to be witnesses, especially with the pressure currently existing in relation to Ukraine. So they need to know what their information is used for and how they can also have a say over the information they are providing. So all of that, I think, really matters at this very moment very much.